Get started, Ernest. We'll be back shortly, I'm sure. We left off at the legal report. Go ahead and start, Benton.
Thank you, Mr. Chairman. The first complaint, I'll start with the original legal report and then put the addendum there at the very end. The first complaint is case number 2012001551. They have a license status of BC-A and CMC and $543,000 and expired on November 30th, 2012, and a complaint history of one prior closed complaint. The complainant alleges that the respondent performed work poorly and failed to pull permits.
Let's go through the ones
Okay.
that,
All you ought to do is just the ones we changed.
Just the ones you changed, right?
Oh, okay.
That'd be
The way
easier.
I did it with the funeral board was I would go through and read the entire report. But if you all wanted, that's fine with me.
We're alive
There's a
and
lot
well
on
here.
there, so I enjoy that. Then okay, that's much better than.
just advise us of anything that's changed to the written report that you gave us before.
Okay. That's much easier. We will turn to number 4. Do I just need to make you aware of the changes?
Yes, sir.
Yes.
Okay. Great. And the recommendation for that was to discuss a recommendation of modification of a civil penalty of $1,000. And the subcommittee recommended that it be changed to $2,500 instead of the request of $1,000 from the respondent's counsel.
Give us all of them, then we'll approve it.
Okay. Number 5, that was a recommendation to discuss, and on that one, they recommended that we have a member of a single member of the board to review the file. They recommended Reese Smith, and there was some question as to whether or not it was a commercial case. And number 12, the recommendation as to respondent number 2, the general contractor, was to authorize a formal hearing along with authority to settle by consent order of not less than $3,000, and it was recommended that that be changed to $5,000 to match respondent number 1 in that case. Number 14. The recommendation was to discuss, and the subcommittee recommended that this case be dismissed. Number 24, the recommendation was to authorize a formal hearing with authority to settle by consent order for not less than $500, and they increased that to $2,000. And number 29. Recommendation was to authorize a formal hearing along with the authority to settle by consent order of not less than $1,000 plus court costs. And it was recommended that that be changed to not less than $3,500 plus court costs. And number 34, the recommendation was to discuss that, and the recommendation was to authorize a formal hearing and settle for nothing less than revocation of the license. Number 39, the recommendation was to discuss, and instead they recommended to close this as it was a civil matter. And number 41, this is now under commercial. Number 41, they asked for more information from the architect, and in this case, we decided that we will withdraw this complaint until the next meeting, until we find we're able to obtain the report from the architect and provide more information in that case. And did you want to move to the addendum and complete those cases before?
Let me ask a couple of questions before you do.
Mhm.
On number 34,
That's correct.
Okay, and on, number 21,
Yes, that's correct.
Your motion to approve everything but the addendum.
Motion.
Is there a second?
Second.
Any other questions? All in favor, say aye.
Aye.
Any opposed? That motion carries. All right. Benton, addendum, please.
Right. In, I guess technically in number 1, we recommended, we were discussing whether or not that should be dismissed, and it was determined that that should be dismissed in that case on the addendum. Number 2, it was determined that we should authorize a formal hearing and settle for nothing less than $1,000. Number 3, it was determined that that one should be closed. Also, number 4 and number 5, it was determined that those complaints should be dismissed. And number 6, it was recommended that we have a formal hearing and settle for nothing less than $1,000 in that case.
Your motion for approval.
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
That concludes the legal report.
Next on our agenda is, Carolyn, are you going to present this discussion about temporary agencies providing labor?
I'm going to let Keith explain
Okay.
it more.
I was asked by a local electrical inspector in Johnson City to look into a problem that he's run up against, and I believe it to be a problem that we're going to face, and I'd kind of like to get the board's opinion of the fact of temporary labor. The way the job played out up there, it's an apartment complex, multi-units, 125, I believe it to be exact. Contractor has the job, and electrical contractors won the electrical subcontract, has no employees, and in turn enlist a temporary agency to provide him with the employees that he needs to complete the project. The temporary agency is not a licensed contractor. They, however, pay all the workers' comp, general liability, payroll, the whole associated payment of paying those employees. Are they subcontracting?
Who directs
The
what they
electrical,
do?
the electrical contractor, I'm assuming, directs them, but they are not his employees. He does not tell them where to show up. The temporary agency is the employer and directs them where to go.
But once they get there, the subcontractor tells them what to do.
Yes.
and if they're not doing the job, the subcontractor can send them on the way, right?
I would assume. I'm not privy to exactly all the workings. It's just,
That's typically.
it becomes, to me, an issue of, does the temporary agency need to have an electrical license if he's providing electrical workers? I don't know how to feel about it.
Are these workers experienced?
That's
What are
another
they
issue.
doing?
We don't know whether they have any electrical experience. We don't know if they're, I mean, naturally, the work has to be inspected, so at some point in time, the work's being conducted properly, or they would not pass inspections.
Well, I read these Alabama and West Virginia court decisions. And the Alabama and West Virginia court decisions seem very similar. in the stuff that we got ahead, that if the temporary company advertises for the temporary workers, saying we need temporary workers to be construction, they should be licensed. But if they just, but there was a suggestion, if they just say, we need temporary help, we're going to send you over there to do whatever you're told to do, then maybe not, which is a very fine line.
You're cleaning up the job site, that's totally different than if you're running wire and,
Typically, they have craft people that would be electricians or plumbers or carpenters.
If they're just doing menial, and I think they use the term menial work, like if, you know, cleaning up your stuff. That's a different, the courts in those two states anyway viewed that differently than if you're saying, we're gonna send you. So, that doesn't mean a Tennessee court would rule that, but I thought that was the closest thing in all this stuff I read is some kind of a guideline, and it's even that is confusing, because then you have all these, well, what did they say, and how did they advertise it, and what did they say to the people? I mean, better off than you are about knowing exactly what to think about it.
I'm under the impression, this is just a, off the top of my head thought, is that they are performing tradesman work. The company is providing tradesmen, which in effect renders them a trade contractor.
Yes, sir. Yes, we can.
That's probably going to be the best way to approach it. I really hope that somebody from the Department of Labor would be here today so they could go, well, that question's been asked and answered. And we could get some kind of resolution that I could take back to the inspector, or at least the board arrive at a decision. But I'm afraid if we try to make a decision on our own, that we could make an improper one, or one that wouldn't pass appeal on down the road, and I don't want to do that. However, this project is gaining full steam, and it appears as though they're going to head on into it as they've bid the job, and I'm just a little concerned about public safety. If you get, and in a project of that multitude, Cindy will attest, there are going to be hundreds of places that errors could be made that may potentially not be discovered. And if the same unskilled employee makes that same error throughout, you're putting many, many lives, up to 250 or more, depends on the number of residents. You're putting those lives in danger. And I would like to see if we can expedite that ruling, so a decision could be made as to rule toward this.
I would be more than happy to work on some language for the next meeting and present it to the board at that time.
He's saying that we're going to ask for some rulings right away.
We need some help, because if they're supplying electrical people, why wouldn't they supply plumbers or heating and air people?
are they operating like a union?
Temporary services do supply all those people, but they're
They're
supplied
operating
to
like a
the
temporary.
licensed contractor,
And the
who is
licensed
then
employee.
responsible.
Yeah, I was going to say, the licensed contractor be the one responsible for them. He's the one that's going to get the first heat.
Right.
Seems to me that this is a
Just like the
situation ripe
licensed
for
contractor
abuse.
hiring somebody off the street, if he can't do the trade he says he can do,
Pay
then
electrician
it's
rates.
his responsibility to get rid of
Plus
him.
you have
They're not
experience.
licensed. Well,
See, we have no way of knowing.
Job comes available, then they turn around and send you over.
Labor service.
And a lot of times you do have to give a resume to the Matter of fact.
I think
you
y'all are
have to give a
killing the court
resume
reporter.
To most temp agencies as to what you can do and what you can't do.
I understand.
So what are we asking,
First, let's ask the Department of Labor. Keith brought up a good question. They may have already decided this. So let's authorize Carolyn to make an immediate, or staff to make an immediate request to the Department of Labor if they have any insight on this question. And that, and then, barring that, I think we need to ask the Attorney General. But
Want me to ask
Keith's
them?
raising an immediate issue. I don't know how to address that.
Want me to ask them how they handle,
Asking the same question Keith asked. Are they required to be a licensed, what?
Subcontractor,
Subcontractor.
would they have to have, in this particular instance, an electrical contractor's license?
they're gonna refer that back to us. They can't answer licensing questions. Labor can only address like the employee, the 1099s, who's a subcontractor, who's an employee. I don't think they would address if they need a license.
So we need a legal opinion on this.
your
Attorney
search
General's
of all
not-
the other states, you've not found any state that
I haven't, but I didn't spend a whole lot of time on it, maybe a half a day is what I spent on research, but there wasn't a whole lot to pull up. I mean, that was pretty much all I could pull up. Most of it had to do with the employee misclassification. Anytime you entered any kind of question like that, it popped up, employee misclassification, about who's a subcontractor, who's an employee, but not anything about licensing.
Be pretty tough for a temporary agency to take a plumber's license, electrical license, and take a BC license.
I can understand a temporary employment agency sending you people that sweep the floors or haul garbage out of the buildings, manile labor. I can understand that, but when we get into trades work, I have a real problem with it. It just seems to me as though we're trying to resort, in my opinion, to resort paying what they would have to pay true tradesmen. Now, I'm not sure what the wages are, and that may be an unfair accusation, and I probably would like to withdraw that statement. However, there has to be a convenience factor for some reason here. And I just want to make sure that in my terms of protecting the public safety, we don't want to get to the point to where large projects like this are completed by completely unqualified laborers. That's my only concern.
Well, I have another concern, and that's an exploitation of labor. Because it's conceivable that someone who doesn't want to pay a tradesman would say, if you want to work on this site, we're going to hire our people through temporary agency ABC. So you go to ABC and talk to them, and we're going to hire some people over there. They may send you, they may not. So here you are. You're a qualified electrician. You hadn't got work. You're desperate to put food on your table. And this company over here has figured out a way that they can get your experience and your qualifications and pay you minimum wage plus $1. So you're right about the safety, and that's the number one thing, because we don't want anybody dying, but I think we ought to also be concerned about the potential of exploitation of qualified people who are desperate for work by not paying them a decent wage and making them go through a temporary service they get a temporary, what they're calling a temporary person on a job-by-job basis and not paying them anything for it. It's a potential for that, and believe me, people, when they find out these kinds of loopholes, do it. I think, we do need to maybe we need to write a rule. Maybe we need to think about rulemaking on the whole thing for the long term. And I'm not exactly sure how we address it here in this short term, but I'd like you to look into writing a rule to prevent endangerment of the public safety and exploitation of qualified workers in this kind of a system.
And I could also do some preliminary research as well to
Assume that you would have to
do that.
So.
See how other states have treated this matter.
And if you find something pertinent, can you keep the board apprised, send us all an email, keep us updated as to any enlightening facts that you may discover?
Yes, sir.
This fallback, like when the board licenses contractors, when you ask if they have any employees, they check no. I mean, the majority check no employees, so they're hiring their employees, their subcontractors from somewhere.
It's
They
done
are.
all the time,
Yeah, it's gonna be
Yeah,
like
so-
Santa Claus, it's everywhere.
yeah.
They are, but the technicality of it is if the job's over 25,000, their subcontractor's gonna have to have a license too.
If it's electrical
So
plumbing.
what we're doing here is we're saying, okay, you're hiring a subcontractor temporary agency to do your work, and they don't have to have a license. And I say they do. That's my opinion. But my opinion may not count, but I think they're in the business to provide tradesman labor, and therefore they should have a license to provide that labor if it's over 25,000. And I tend to be inclined to think that this particular job in question is well over 25,000.
I think we've got some direction for Benton. We'll talk about it again at the next board meeting.
Add it to the agenda for the next meeting then.
Next item is letter of credit, 50% rule for negative working capital.
This is, we were looking at a financial statement, and this is a rule that I don't know if how many of you are aware of this rule, but how many times, like in just renewals, not new apps, but a contractor, if he doesn't know that he has a negative working capital, then he turns around, he submits a line of credit to get him up to what he thinks, and he's always having to turn around and go back to the bank because we only take it at 50%. So I just mentioned this to Mark, that this might be something we want to look at. It adds an additional burden to a contractor, and they have to go back to the bank, and then whether or not this doubling the line of credit is adding any kind of additional protection. So I just wanted to bring it to your attention. It may not be anything you want to act on, but just sort of bring it to your attention.
Are you saying if a person has a line of credit from a bank of $100,000, we are
Right. Right. Most contractors aren't aware of that. So when they're doing all their paperwork, they'll diligently try to get everything they need, and then they turn around and find out, oh no, I only,
Twice as much. line
yeah, I
of
need
credit.
twice as much. So it's adding a burden on them at the same time. They've got a negative working capital as it is, so they're having to go back and pay more.
So the solution would be if you have a line of credit from a bank, accept the whole line of credit, and that would eliminate.
Right, to just do away with that last sentence in the rule.
What was the thinking of the 50%?
I don't know, because it's been there way before
Most
me.
lines of credit are drawn upon and aren't worth the entire total as it is. I don't know.
When I get a line of credit, I have to give that much or more in collateral to get a line of credit from the bank. So if you get one, you shouldn't be penalized up here. I think we need to do away with that line. If you can get a line of credit, because you've got to put collateral, a bank's just not going to give you a line of credit unless you've got collateral behind it.
The bank makes it really hard.
They
and-
do. I mean,
and
it's not
then-
an easy thing to do.
And then they turn around and go back to the bank and said, the state says this isn't enough.
And then you get your banker all upset with you because you've already asked for that. And typically, a line of credit's not good but for a year, and you have to renew it every year.
Yeah, it's only good for a year,
A
so.
lot of them not able to come back at all then?
They do come back, but it's
Come back,
usually,
but
they're unlicensed for a few months until they can get it back, and then we usually end up having to talk to the banker, because the banker doesn't understand what's going on, so.
I would like to strike that 50% rule. Once when you get it, it's tough to go back for ask for seconds.
Oh, right, within the same month.
Is there no record of the conversation as to how this 50% rule came about?
No,
Can we ask Reese?
yeah, we could ask Reese. That's a good
I would-
idea.
Reese is all knowledgeable about most of these things.
Right.
And I would like to ask Reese before we make any jumpy decisions, and we would have to do a rule-making hearing to change this as it is, so the process will take some time. So if we could ask Reese and then just let us all know, and we can,
That's a good idea, so I'll table this.
I don't have a problem with that, asking Reese.
Okay. Then, the next item on the agenda is the
Before we move
reciprocity.
on, Carolyn, I'm going to
Oh.
have to excuse myself. I got to get on a call here at 3
Okay,
o'clock.
that's fine.
Pass the gavel over to Jerry.
Okay,
I'll be back in an hour. Done by
we'll
then.
be gone by then. Just go ahead and drive home.
We'll call you.
next item for discussion is the reciprocity policy review. This is another issue that Keith brought to our attention. He's been asking about this for some time, and I think I just sort of keep pushing it off. But it is something that we need to look at. We've had a reciprocity agreement since probably 1998 with several states, and one in particular was with Arkansas, and they do not have trade exams with their general contractors license board. They actually have like separate licensing agencies, like I think plumbing, maybe through the Department of Health, and they require exams, but they don't have to have an exam to get a license with the state licensing board. So he wanted me to sort of bring this up, to relook at our reciprocity policy, to see if we want to continue continue waiving our trade exam for Arkansas. And Keith, you might can explain it a little better.
Something Carolyn brought up to me was that South Carolina, which we reciprocate with, has now gone to the fact that if I were to go to South Carolina and apply for a contractor's license, I would have to provide an audited financial statement, no matter what the limit I sought.
It's actually Mississippi. I got my
Was it
state-
Mississippi? Okay,
Yeah, I
well,
got my states mixed up.
It's Mississippi. That makes it even worse. But if we're not, I'm in the opinion, if we're not apples for apples, our license to their license, then we don't have a reciprocity agreement. We have we'll take your licensee under our agreement, but you have to take our licensee under your arrangement. It's not the same, if I'm clear enough on that.
Right, and we weren't made aware of the policy change. We just, I don't know how long they've had it like this. We just sort of learned about it about 6 months ago and found it on their website. And then what they'll do, if the contractor takes the Mississippi exam, they will waive the audited financial statement. So it's not really.
Another exam fee, and I'm under the impression that that was the whole reason for the reciprocity, was to keep the duplication of exams and to keep the duplication of financials and even a more burdensome financial if you don't want to take the exam. What's the board think? Is it fair, or do we need to live with it, or do we just drop reciprocity?
I like
It
the
is
apples
fair.
to apples idea.
Apples to apples.
It just,
That's something that I think I'd like to make it an emotion that Carolyn write a letter to the states that we reciprocate with and state, in as much as we would certainly desire to continue our reciprocity with them, that if our reciprocal agreement is not completely and totally 100% identical with ours, then we will have to rescind that reciprocity. Now, what brought it up was it just seems like I have been inundated with Arkansas contractors of late seeking to get a Tennessee license. And knowing that they've not had to pass a contractor's exam, and it seems to give them an advantage over people that have had to already, go through the Tennessee end of it and take tests and pass examinations, and all we are allowed to do is either approve or disapprove the application with really no knowledge of their qualifications.
I understand what you're saying, but I think you should penalize those people that already have a license with Mississippi and Arkansas or Tennessee. I think all those people who already have them need to be grandfathered in.
Well, I don't
Because
think
you're
we
gonna
could,
have
I
a
don't
lot
think
of
we could
people-
kick them out anyway.
Well, I don't know. I mean, I don't know what's going to take place. If you turn around and start requiring that, then they may say, you're going to have to do this. Write that letter. I think you need to make it clear that if you already have a Tennessee license or an Arkansas or Mississippi license, then you bothered in. Now, going forward, we might do this
future life.
for future license, but those that already have it, don't penalize those that already have it.
I think we'd have a legal issue trying to do that anyway.
I don't think we could. I'm just talking about for the future,
I understand.
from this day forward.
I'd say that Mississippi's requiring an audit.
Situation that Keith's talking about has a potential of putting a lot of unqualified contractors into our state, building stuff for our people.
It could.
And that's just not something we want to happen. Here's a question I have about reciprocity. I brought this up before, and I just worry about some kind of a chain out there. And now I'm talking about Arkansas. If Idaho has basically no standards at all because they're super libertarian, and they have a reciprocity agreement with Wyoming, which has one with Oklahoma, which has one with Arkansas, which has one with us, what's to prevent somebody in Idaho with no qualifications whatsoever having a reciprocity, entitlement in Tennessee?
Well, we do have a policy that states that you would have to have been licensed in your domiciled state, so that way you don't get a license in Idaho just to be able to get one in,
That chain.
jump that chain.
And that's for any kind of reciprocity license.
Right, and we do have, we also have in there that it just, in case they did get licensed in Idaho, but had they taken a test and say another state that has the same exam as us, we would still reciprocate if they, for instance, if they got their license in Idaho and then they reciprocated with Louisiana, then we would take that license even though they didn't take a test with Louisiana if it was found where they took a test similar to ours, say in California. That's just an example. So
Somewhere they've got to take a good test.
yes, so the board can still accept the reciprocation, but you can put guidelines on it. So it's just whether or not, and we do have on our form what was the basis of reciprocation. And so, and Brenda is our reciprocation expert. She handles all the states, and she'll put on there whether or not it was through grandfathering, whether or not they passed a test, or whether they was granted a license because they were reciprocated with another state. So,
Well, red flag, some kind of suspicious looking chain of reciprocity.
right. So
Okay.
that's it's on there on the reciprocation form of how they got it, whether they took a test or not.
Okay.
Did I make a motion? I make a motion that Carolyn draft a letter or send a letter to the agencies that we reciprocate with and ask for equal and compatible, is the word compatible correct?
Comparable or
Comparable.
Licensing in order for us to be able to continue reciprocity?
For future license.
For future license, yes.
would it be okay to just do it for those two states since the other states are okay? I don't want to. Are you sure the other states are okay? Yes. I went through them.
As long as we're apples for apples, I have no problem. It's the ones that are strengthening or weakening the licensing process as we have adopted that I have a problem with.
And I will meet with them in August, so I can probably get with them and see about getting a new agreement form that says that with all the states. But I just think right now, rather than sending them a letter, that might be a little too cold, but just address the two. In Arkansas, the director with Arkansas, he completely understands. He wants exams, so this is something he would be completely understanding with. Oh,
Have a motion.
We have a motion, do you have a second?
Second.
Those in favor?
Aye.
Opposed?
legislative update. Find it in our tablet. Tab 119. The similar name bill that has pretty much passed. It's been signed by the governor, but it has not been assigned a public rule, a public chapter rule. So this just, it gives us a way to keep contractors from getting a license in the same name. And it was put in place mainly by two complaints we had where contractors had actually seemed to be taking over a name that a company had already been established for several years and even moved on the same street. And so he didn't have that licensed name. He was licensed in another name, but he was advertising in the name as the other company. So,
Right, I sent one back, and I sent it back to Kathy this past time, a name change request, and I forgot exactly. One of them was American Contractors, or American Great Contractors, and then the other one was American Great Contractors with a K. And I thought, well, I don't think so. And she ran it by another board member. Thought, well, that's significantly different enough. I guess we're going to let it happen. And that's fine. I'm not arguing with that board member about that. But it seems to me that those kind of generic things can create problems. You know, it might not if one of them's in Memphis and one of them's in Knoxville, and they're kind of doing local work. But how do you know? You got a state license, not a local license. So I'm all for that. But I don't know how diligent we're being about those.
Well, we were really, when they talked about this bill, it was mainly as a complaint issue. When we get a complaint, it says, hey, he's stolen my name. I had this name first for years, and he's come in behind me and got this name. Then we could open a complaint, and then that is if we don't catch it on the front end.
Well, the only reason I knew about it is because it looked like such a generic name. I just said to myself that that's got to be somebody else's name, and it was. And they were both LLCs. I mean, it was just, and I just kind of looked it up on the website myself. And I know, I mean, I'm not. It's not like y'all don't have anything else to do than look up every name to see if it's there again. And we make them check a box that says they've checked it to make sure it's not the same. But if that's what the name they want, what else are they going to put? But if you change the letter from C to K, that's not much of a difference to me.
But by law, with Secretary of State,
we've got a law now that says we have to do that. So what does this mean for you work-wise?
Well, we'll try, and if we mess up, we'll fix it by complaint. But I mean, it's something where you're right. It's going to be hard to check every single one, but it will be something where we'll add contractors like we do in home improvement. We'll advise them to check to see that nobody else has that name.
There's an eye test on it. Grouching, splitting contractors, you're not going to have to worry about. But all American roofing is something that you say bound to be there somewhere. So.
And Kathy knows which one she's got her own database right now. She knows the same ones that use the same name. So, but we'll try to catch it, but it's going to be some we don't. But when it does come through, we'll have a means for the board to take action to get the contractor to take his name where we didn't before. And also, Representative Ramsey, right before the bill passed, there was questions from the other representatives and senators. They wanted to make sure that the board wasn't going to prevent family members of having the same name, and what if there was individuals that had the same name. So he wanted to make sure that there was a way to show that the intent of this is really to prevent stealing your ID, stealing your trade name, things like that. And so he suggested we come up with a rule and just to clarify that, rather than go through and do an amendment. So I've drafted a little rule in case y'all want to use that. And that's just, this just gives y'all a means to, give like the same, if it is similar, but it's due to a family business or something like that, you can still do it. And it just says the board shall have discretionary authority to individual cases to modify the criteria for an applicant with a similar name if it's determined that the intent does not appear to misrepresent another established licensed contractor.
Carolyn, the law says we are instructed, we are required to deny an application if it's identical or similar. That's very restrictive language. And I hope that we're going to have to run our rule by somebody to make sure that we can even do something like you just said. It's a good idea, and we should do it, and we want to do it. And if it's legislative intent, maybe we can do it. But the law, as they've written it, is very restrictive. We don't have the option. They didn't give us we may. They said we're required to deny the application. That's not such a. I mean, I like the idea of it, but I think we're in a box on it now.
Well, it's just he suggested that to the
He should have written it that way.
He suggested that to the members of the legislature in order to pass this law. He said, well, if the board comes up with a rule, and he gave them that draft language.
Hope that that's recorded and on record somewhere that we need to have in the file to show legislative intent.
Sure, I can.
Because this law is going to put us in a box.
Well, I mean, it's up to you all whether or not you want to do a rule. I'm just telling you that's what they
I
suggested.
understand what you're saying, and I understand what they're saying, but they pass a law and then say, well, wait a minute, we better qualify the law, and that's, you know, you can ask our lawyers what happens when that happens, so.
Okay, the next one was our sunset law, or sunset bill, and it is passing. It hasn't been signed by the governor, but they also tacked on an amendment that I haven't seen before, and this was having to do with residential board member appointments. So I don't know how that changes anything.
What's the language
What is the language
change?
of the
What does that mean?
residential board?
Let's see, let me see what page it's on. Pages. Is the governor, is on page 4 right after, you see it?
Bill.
I don't see that there's that much difference in the language as the way it was before, other than it appears to have added or allowed the governor to speak to other home builders association groups other than the Home Builders Association of Tennessee.
I just want to make
think
sure.
that before it read, shall be supplied by the Home Builders Association of Tennessee, a list of names or something. So this gives him the option to maybe consult other groups as well.
Okay. And then another one that is, it's so far it's passing, and it's the one with the bid envelope where it gives, when the law that says you must list, the name, license number, classification, on that law where it says you must do all this, it gives you 48 hours to fix it if you mess it up. So that bill is changing, and then we will definitely need to do a rule change for it. Well, one of the concerns with Associated General Contractors, they had to leave, but was whether or not when a contractor lists the wrong name, if he lists a name other than what he's licensed as, is that going to fall in the same category of giving him 48 hours to fix it? So,
Well, I guess the intent is if it's like an Inc. instead of an LLC,
yeah, like a typo,
totally substitute company, right?
right. I
That's
mean,
still
it makes
prohibited,
sense.
right? It makes sense, but that this won't let that happen, will it?
Right, I mean, so you probably need a rule.
Make sure that doesn't happen. Okay.
And then the statewide home improvement legislation, it's been assigned to the general sub as of March 18th, and so I haven't seen anything happening on that, so I don't know if anything else will or not. And the amendment that was proposed that had been emailed to several of you, it's not listed on the website either, so I don't think it ever got proposed. Both the draft amendment. And then the bill that you all had opposed about the architects and engineers, it seems like it may have died. It's stuck in general sub as of March 12th. And the elevator hasn't made any more progress, so it looks like it's died. And then the one where the professional tax for all the licensees, it was withdrawn. So that's it for legislative update. If any of you all have questions. And last is a budget update. And that just shows you how much money we've got. Our reports are like 2 months off. You have to turn your iPad around.
Work.
It won't work.
Nope.
Oh. Anyway, we're doing good. We're very lucky that we're not some of the other boards that are suffering. So there's no concerns right now. I believe that's all I have.
Business?
Oh.
We can't have that.
So he may be right back, you think? Oh, okay.
We'll send the enforcer to go.
I think most of you have talked to our next guest. We had explained to him there was no need to interview with the board, just simply complete his application. But he prefers to talk to you all.
Yes, it's your turn.
Good afternoon, ladies and gentlemen. My name is Guy Vanzi. I appeared before this board in November in Jackson, and I came here for a specific reason and question, but unfortunately got sidetracked when I mentioned I had a master's license. One of the board members, and I don't remember which one of you it was, wanted to see my master's license and then mentioned something about getting a financial statement and a one-page thing filled out. But unfortunately, it was not done through parliamentary procedures. There was no motion, no second, no discussion, and no vote, which means whatever was told to me at that board meeting in November does not exist because it didn't go through proper procedures. So I'm going to go back to the original thing of why I showed up in November. In March 20th, 1992, I was issued an electrical contractor's license by the Shelby County Board of Electrical Licensing Board. This license was through all state of Tennessee application processes, testing, and the whole 9 yards. And I was issued a license number 8103. That license has been renewed every year since 1992, so therefore it has never expired. It has never been suspended, has never been revoked. There has never been any action taken against that license whatsoever since it's been active since March 20th, 1992. Now, I can only speculate why it took 2 years, and the speculation would be that it was 2 years after I went in business that I did any work outside of Shelby County. But on August 15th, 1994, I was issued a permanent license number 40598 by the state of Tennessee, recognizing me as a duly licensed electrical contractor. And that's the way it's been up until 1998. 1998 is the last year that I could find a state electrical contractor's registration on file with the state of Tennessee. Now, I know you've got your legal counsel, but I've talked to some legal counsel too, and they tell me that Tennessee cannot make laws that are retroactive. So why, I keep hearing this word grandfather clause. Why I was not grandfathered in because I had a license that was recognized by the state of Tennessee that I'm being told now is no longer recognized by the state of Tennessee, and I cannot call myself a contractor anymore. And that's why I appeared in November, but I never got to present this to it. I mentioned my master's license, and I was told by whichever board member it was, You wanted a financial statement and a one-page thing filled out. And I submitted that, but it didn't fly. And I do want to thank whichever board member it was that asked me for the financial statement, because that's the greatest thing you've ever done to me. For the last 4 years, I have been scared to death to put a financial statement together because I thought I was bankrupt on paper. I'm actually a whole lot more solvent than I thought I was. I got $14,000 worth of working capital and $20-something thousand worth of net worth. And I thought I was bankrupt. And on top of all that, I had a real good last 6 weeks. I've got all my bills caught up. I got $3,500 in the bank. So my financial statement that I submitted to Carolyn is actually $3,500 more than what it was when I submitted it to her. But that is my question. How can you guys tell me, when you recognize me all these years as a licensed electrical contractor, you're now telling me I'm not a licensed electrical contractor? I can see where the LLE came in because the state requires financial statements on license renewal, where Shelby County didn't. When my original application was submitted, and it does state on my financial statement on my original 1992 application, in accordance with Tennessee Code Annotated 62-2-120, my financial limit was based on 10 times my net worth or my working capital, whichever was less. So I even went through that whole process in 92. Back then it was $25,000, so I had a limit of $250,000. They didn't require any updates unless you wanted to up your limit. So I guess when the state took over on the financial responsibility, somehow or another I got left out of it and somehow missed the ball on, and I can see that's why I got lowered to $25,000. But I have a financial statement now that shows I've got net worth and working capital. I just can't understand why I'm not being recognized as a licensed electrical contractor anymore.
I believe in 1992, you had a license in Shelby County and not here in the state. I believe that's what you had told us.
But I have a registration from the state of Tennessee recognizing me as a licensed electrical contractor.
You appeared before us before. You said in 1992 you were recognized in Shelby County, not in the state, when you appeared before us in Jackson.
The state did not. The state allowed the counties to administer the electrical contracting test at that time.
Several
Yes.
things he has said
Yes.
is inaccurate.
Yes. What the board told you to do is apply for your contractor's license. That's what they told you in November. They explained to you what you needed to do, and it's complete our application, which included a financial statement, proof of insurance, reference, and also the fee. And we gave you the application, and you've almost completed it. But we need you to complete that application.
And the board member, when he said you need to fill out an application, I said I filled out 40-something pages, which I've got right here on my original thing. I had to get a bank thing showing 6 months of past deposits. I had to get an electrical engineer. I had to get all kinds of people showing that I had the experience and everything that was required.
You just should have mailed that to
That
us.
man told me, no, Mr. Vanzi, we don't want that. You've already done that. We want one page filled out. And but like I say, there was no motion, no discussion. I was just up at the table talking to you guys up at the table, and this is what was told to me.
You didn't even mail that application.
This is my original application from 1992.
We don't have that.
I offered it to you. You didn't want it. You wanted a new application.
Yes, but if we do need a new updated application, that we do, but you just sent your financial statement in without, you didn't send a fee, you didn't send anything, you just.
You had
you
mentioned
sent me-
that
Well,
I
here,
didn't
if
have
you
to
want a
pay
motion,
the
let's
fee
make a
up front.
motion.
Yes.
I move that if he wants the license that he wants, he complete the application like everybody else, that he work through the executive director to see that it's complete, and then it be considered like other applications as in the next board meeting. That-
Discussion?
Aye.
Opposed? I believe it passed. There you go.
I think since board's contention that you're not going to accept the electrical contractor's license I have.
No.
You're
gonna have
telling
to
me
do a
I
new
no
license.
longer can call myself a contractor?
Until
There's no
you get
such thing as
until
a
you complete this
grandfather clause?
application.
And I,
That's right.
okay. Then I guess a judge will decide.
Okay.
I made it real easy. He almost
Left.
Ernest Owens, Memphis, Tennessee.
Bill Mason, Greenbrier.
Ronnie Tickle, Memphis, Tennessee.
Jerry Hayes, Paris, Tennessee.
Mark Brudd, Knoxville.
Keith Whittington, Johnson City.
Cindy DeBus, Knoxville.
Okay, we have a request to move up a legal report to the top of our agenda. So I'd like to go ahead and do that at this time. Robin, do you?
Oh,
Okay.
sorry.
I don't know that I've been in front of this board before. My name is Sam Payne, and I'm part of the legal team. We're all on the 5th floor. You've probably been up there from time to time. I replaced Wayne Pugh, if that name rings a bell. Wayne Pugh held my last year. I came on right after Labor Day, so I've been here about 6 months. I'm Deputy General Counsel, so my job is to oversee all the other attorneys like Robin Ryan and Jenny Taylor, for example, who y'all were working with. So I don't really necessarily handle the cases myself, but I'm just supporting and managing and supervising the attorneys that do that. Robin does. As you may be aware, and this is the reason I wanted to speak to you first, Jenny Taylor, who's been your board attorney for some time now, she transferred up to the 8th floor, and she's working with fire prevention now, so we wish her well and supported her in that transfer. I wanted to make a formal introduction. Some of you working on the interviews this morning may have met Benton, but Benton McDonough is going to be assigned to you guys going forward as your day-to-day board attorney. Benton has worked for the department for about 3.5 years, all of that with burial services and the funeral board. So anyway, he's shifting gears now, looking forward to this new challenge. He has with him today Joyce Carmichael, who is one of our paralegals, and it's been an exciting time for me. In the 6 months I've been here, we've been able to add 3 or 4 paralegals. So the legal roster is fuller than it's ever been. We have a total of 5 paralegals with one that's going to be starting next Monday. So anyway, I wanted to say hello, introduce myself. Again, I'm the Deputy General Counsel, Sam Payne, and we encourage you to work closely with Benton, get to know him, but if there's any time I can help you, I'm on the 5th floor. Hopefully you know where to find me, and I'll do whatever I can to help. I think Robin has a brief matter, and then we're going to go into a sunshine.
I am a litigator for you all, but I've been before you before. In this particular case, and most of what I do is your unlicensed contractor cases. And I had a set of them earlier this year, and one of the respondents, which is why I'm here, has submitted, and he and his attorney and I have submitted what we hope would be an acceptable agreed order to you. Let me give you a little background. It is an unlicensed case. After I filed the notice of hearing and charges, it was discovered, we were told, that this particular respondent had filed a Chapter 13 bankruptcy. Now, that does not stop us necessarily from going forward if we were taking a license, and may not stop us necessarily going forward if we were trying to get a judgment, but we can't collect unless there's some sort of agreement. So, his attorney agreed to the terms that was presented earlier, which was $1,000, or not, I think it was $1,000 civil penalty, and agreed to pay the court costs, which right now are just $200, and agreed to have all this paid through the Chapter 13 bankruptcy. And that's the agreement I'm presenting to you today, and ask for your approval so that I can file it and finalize this case. But I wanted to invite you to have any questions you might have, if you have any. If not, if it's approved, I do need your approval.
Do you have any questions? Do we have a motion to approve?
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? All right.
Thank you very much. I should let you know that we have our star witness for the next hearing coming up in April on several more unlicensed cases. And so, thank you again.
Thank you, Robin.
Mr. Chairman,
Yes, sir.
if I may, that case pertains to number 2 on your legal report today, so that will take care of that
Okay.
issue.
Thank you again.
Okay, good. Moving right along, I mentioned Damon. This is Damon Romano. He is a third-year law student at Belmont School of Law, and will be part of their initial graduating class, which I think is exciting for Belmont and for him. He has prepared a PowerPoint. We've been giving it to several boards and commissions. I think we've got 5 or 6 down and 8 or 9 to go, but it's something that I think probably each of you has heard about. You may feel like you know a lot about it, and this will be a good refresher. On the other hand, it may be something you've always had questions about, and hopefully Damon can clear those up. I am here simply to support Damon. He's done the heavy lifting. He will take questions at the end, kind of in the interest of time, maybe hold your questions to the end, but I will turn it over to Damon. Thank you.
Chairman Brudd, ladies and gentlemen of the board, I appreciate you having me this afternoon. I hope you will forgive me not going right to the microphone. If I were a preacher, I would probably be one of those that wanders up and down the aisles real irritating like and tries to keep your attention. I do that, so I appreciate you bearing with me. The presentation will appear on the screen over here. I know that's kind of a weird angle for some folks. I've also brought down the screen behind you, so if you need to take a minute to shuffle your chairs around, if that'll make you more comfortable, so you don't have to twist your heads around backwards. We'll be talking this morning about the sunshine laws. There are, when we talk about the sunshine law broadly, we're talking really about 2 laws, excuse me, the Open Records Act and the Public Meetings Act. The Open Records Act is something that I'm just going to touch on very briefly this morning. It is, as a matter of course, as a matter of day-to-day business, something really that Director Lazenby and her capable staff take care of. What is open records, though? Really, this becomes important for y'all when you are talking about Freedom of Information Act requests, access to any records that you all might keep as part of your business goings on as a board, excuse me, that somebody in the public might want access to. What is part of open records? You can see there the law says all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files, and output, films, sound recordings, or other material, regardless of physical form or characteristics. And so that ought to give you an idea that what they mean is everything. Pretty much everything you do is going to be subject, paperwork-wise, to those open records requests. Now, whether or not they're granted is a different question, and that's really, again, a process that's handled on a day-to-day basis, processing those requests by Director Lazenby, or in much more involved and somewhat rarer cases, there is a state open records council, a whole legal office that handles those types of things. Let's start digging into the meat of it as far as we're concerned, as far as you all are concerned as board members, the Public Meetings Act. We'll talk today broadly about 4 points. What is the Public Meetings Act? What is a meeting in terms of how it's defined under the law, and then what it's not. That can be kind of an amorphous term. And so try to do is put some fences around that and give it some shape. Once you know what a meeting is, then what are you required to do? Broadly speaking, the notice, the agenda, which we'll find out we're not tied to an agenda. It's really just a conventional format. And I guess we really haven't found a better one. Public presence and minutes. We'll discover that once we figure out what a meeting is, and once we figure out what our requirements are under the notice provisions, that's going to cover about 90 or 95% of everything that you all are required to do. Penalties for violating the Sunshine Law, very briefly, they're nullity. It will be as though it never happened. And that flows down the line and can have some fairly serious consequences that will snowball pretty quickly, as we'll see. I will tell you, or Sam already told you, I'm in law school, and so I will do my best to not throw legalese at you, because I have learned after 3 years of law school to hate the stuff. But there are a couple of laws that we do need to talk about, and rather than trying to overcomplicate it, I'll just put the law up there for you. There are a couple of cases, just 3 or 4, that are, again, I'm not going to dig into the minutia of how judges thought 50 years ago, but those few cases are important to look at. So we'll get into the law then. General Assembly hereby declares it to be the policy of the state that the formation of public policy and decisions is public business and shall not be conducted in secret. Public policy is going to be your rules and regulations. Anytime you all adopt a rule or a reg, or amend one, or go to deleting one and replacing it with another, that's the public policy. The other component of that is your decisions, which is pretty much everything else that you do in terms of discipline, granting of licenses, revocation, suspension, all of that kind of stuff. Continuing education. This part is the free speech section of the Tennessee State Constitution. And what they're saying there is that, look, you all have taken an oath to serve on this board and to follow the law as it applies to this board. They're trying to explain to you that that does not run over your rights as a citizen of this state to have free speech. The way to read those two together then is to say, look, at state legislature is not telling you what you can and can't say. They are telling you that when you are acting in your capacity as a board member, everything that you do choose to say really needs to be on the record and made available to the public. The act is remedial in nature. What does that mean? In plain English, we can't fix a problem before it happens. As a court system, as a legal system, if there is some sort of a violation of these sunshine laws, there's nothing we can do about it beforehand. We have these laws in place to try and say, hey, look, we want everything to be above board, but if something bad goes wrong, the only thing we can do is fix it after the fact. And therefore, we're going to construe these laws very broadly in favor of the public. Okay? Accountability in government is the phrase that the court uses there. Excuse me. The idea, and you'll see the courts and the state legislature returning to this over and over again, every single time they deal with these sunshine laws, this very broad, expansive language, it comes up or is quoted over and over again about protection of the public. Why? Well, the thinking is, look, if y'all vote for a governor and he's doing something that you don't like, you vote him out of office, right? You all have been appointed, not elected. And so these sunshine laws are there to kind of give the public a throat that they can put their hands around and shake if they don't like what y'all are doing, okay? And so that's where that language comes from. Next part of the law. All meetings, again, this very inclusive language, all meetings of any governing body are declared to be public meetings open to the public at all times. except as provided by the Constitution of Tennessee. That except is a very narrow exception, refers to what's called the executive session exception, and we'll talk about that in more detail a little bit later. Absolutely applies to this board. It applies to any governing body. Well, then, what's a governing body? Okay. The statute tells us that a governing body is the members of any public body which has 2 or more members with the authority to make decisions and so on. Well, if a governing body is just a public body, does that really answer our question? Doesn't it just move the problem back a few steps? You see there in the fine print, if you can read it, the Tennessee Supreme Court in another case tells us that the legislature intended to include any board, committee, agency, authority, or any other body by whatever other name who has the authority to make decisions. Excuse me. That definitely picks up the Contractors Licensing Board. By the way, that governing body of a public body means own the coop.
Yes.
Miracles of modern technology, folks. I keep waiting for it to make our lives easier. Until it does, we'll do it the old-fashioned way. All right. Governing body of any public body. What they're trying to do is tell us there that subcommittees and committees are also included. Next, we're going to talk about what is a meeting. And you would think that's pretty easy. It's a little bit broader than we would normally anticipate. Before we get into what is a meeting, and I appreciate your patience, before we get into what is a meeting, let's talk about what's not a meeting. First of all, what's not a meeting is any on-site inspection of any program. Anytime one of you goes out to inspect a job site, that's not a meeting under the law. What else is not a meeting? The law says that a meeting does not include a chance meeting of 2 or more members of the board. However, no such chance meeting or informal assemblage can be used to decide or deliberate public business in circumvention of the spirit of the requirements of the act. So that's the spirit of the law provision. Excuse me. This brings us to the first case that I wanted to mention to you this morning. The case is called Aiken. In Aiken, you had the town of Kingston Springs, which some of y'all may be familiar with. Kingston Springs, the town council got together and they said, we'd like to annex some of the unincorporated property around us. And though they made the final vote, yes, we want to annex, in public, in a meeting like this one, under the gavel, publicly noticed, everything was fine. The decisions about exactly which parcels of land to annex, where the lines were going to be drawn, they did those meetings in secret. And so, as you might imagine, some of the people who got annexed weren't happy about it because now they're subject to city taxes that they weren't before. And so they got sued. The town council of Kingston Springs got sued. Eventually, this case, by the way, goes all the way up to the Tennessee Court of Appeals. So that's, if you're counting it, at least 3 lawsuits, the original one and 2 appeals. Eventually, the Tennessee Court of Appeals says they violated the spirit of the law, but we can't find where they broke the letter of the law. And so they said there's no violation, they let that annexation stand. And you say, okay, well, the government body wins there. We don't, as a board, have anything to be worried about. And that's where I would stop and back up a minute and say, folks, I would suggest to you that if you get sued, you've already lost. The vast amount of time and resource in terms of your staff time, your staff attorney's time, God help you if all of you have to be called down to Nashville 2 or 3 or 4 times to get subpoenaed, give testimony in court, so on and so forth. It is a massive black hole of time, attention, effort, money. So that's one thing. The second thing is, after that case, after Aiken, where the court said, well, the town of Kingston Springs, the city council, they win. We can't find a technical violation because they did the final vote above board. That's when the state legislature came in and passed that section of the code that I just read to you that said it's a spirit of the law provision as well. So this chance meeting of 2 or more members, in other words, if one of you runs into the other one at the Piggly Wiggly on the weekend, that's a chance meeting. If one of you undertakes to call the other one on the phone, and we'll talk about electronic or non-personal communication a little bit more in a few minutes, that's not a chance meeting. One of you took the initiative to pick up the phone or got on the computer to type that email. The court's going to say that's not a chance meeting. One of you took a deliberate step. All right, what else is not a meeting under the law? 2 or more members of a public body may share a meal together in which public business is conducted, but the discussion should not constitute deliberations. And if that sounds a little bit confusing, it's confusing to me too. That is from an opinion of the Tennessee Attorney General. So it's not binding law from the court, but it's as close as we can get. Again, ladies and gentlemen, I would submit to you that if you have a pretty good idea about what you think a judge is going to say several months from now as to whether or not your conversation outside this morning was appropriate because it was discussion or was inappropriate because it rose to the level of deliberations, you're smarter than I am, which is probably the case anyway. But that's, you see what I'm saying? They're putting out this standard saying you can discuss business, but it shouldn't rise to the level of deliberation. I would submit to you that that's a line that maybe we want to back away from instead of trying to cross. So if you run into each other at the grocery store, go to church together, meet each other on the golf course, whatever it happens to be, have lunch, talk about your kids, talk about the weather, have a party. But whatever you don't do, deliberate, debate, or decide board business. Those 3 key words, by the way, deliberate, debate, and decide, those are all key words that courts have used to describe violations. And so those are the kind of activities that we want to stay away from. What's not a meeting? Lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions, adjournments between 2 days. If you have a 2-day long meeting and you adjourn, at 4:30 or 5 o'clock at night until the next morning, excuse me, that time in between is not a meeting. Of course, it also means then is you ought not to be discussing about board business. All right. And I'll forward this to y'all later if you want, or give it to Director Lazenby so she can forward it to y'all if you think that'll be helpful to you. Excuse me. What else is picked up? Regular meetings, such as this one, and any special meetings. Special meetings the courts have held have also included emergency meeting. If you ever had to hold an emergency meeting, I don't know if y'all ever have, if there's a real time-sensitive licensure problem and you can't wait till the next regular meeting. Notice, even your emergency meetings are set 2 or 3 weeks out. Why? Well, because they're covered under this Public Meetings Act, and y'all are required to give public notice, allow the public to be in attendance and do everything on the record. I mentioned earlier that our only exception is the executive session. What's an executive session? 3 things go into it. First, an executive session occurs when one or more of you, and it can just be one of you, meets with the board's attorney, and the board is either under lawsuit or has been threatened with a lawsuit. And if any one of you has a reasonable idea that the board might get sued over it, that's enough for you to go into that executive session, okay? If somebody comes to you in the hallway during a bathroom break and says, I can't believe what you people are doing to me, this is baloney, I'm gonna sue you. That's plenty. That's a credible threat of lawsuit. So you can then get back to it. So one or more of you gets together with your board's attorney, Mr. McDonough, and the board is under suit, or you think it's about to be, and you're getting together to ask your board counsel for his sound legal advice regarding that suit or that potential suit. What you cannot do in an executive session is debate again or deliberate about any issue that is actually before the board or might potentially be before the board. Okay? That's the kind of stuff that we always want to have available to the public, into the microphone, under the gavel, on the record. Okay? So, for example, some licensee comes to you, Mr. Whittington, and says, I'm going to sue y'all. I don't like the way I've been treated. Okay. That's plenty for you then to go to Mr. McDonough and say, I need to have an executive session, or maybe we all do, as the whole board, have an executive session, sit down with you and say, so-and-so has threatened to sue us. He told me in the hallway. Tell us what's going on. And that's an opportunity then for your board counsel to provide you with his sound legal advice, as to say, look, if you do X, these are the likely consequences. If you do Y, these are the likely consequences. All right, executive sessions. So you get together, he gives you his sound legal advice. If you then say, okay, well, based on Mr. McDonough's legal counsel then, I think that we should do X. No. Now we're getting into the point where we're sharing our opinions with one another as though we would in a debate right before taking a vote. After we get our good legal counsel from our board attorney, that's when we need to stop, take a step back, get back into the committee chamber or the board chamber, get back on the record and under the gavel, and then make our debate there. Okay? The idea of having this executive session off the record is to preserve what you might have heard of, attorney-client privilege, right? Because Mr. McDonough is your attorney, the board's attorney, and he can give you legal counsel as an individual member if you're acting in your capacity as a member of the board, right? If you get picked up for your 19th DUI in 15 days, he's not going to be able to help you out with that. You're going to have to get another attorney. How far does it go? This idea of I have it here under executive session, but really we're back under the idea of how far does it go? How far does the state legislature intend us to apply this idea of keeping everything on the record? Here we have the Maury County Civil Service Board. They were taking first level interviews for jobs, and the idea was that they would interview these people, these candidates, applicants for jobs, for the first round of interviews. And the people that passed that interview, they would have the interviews, and then the Civil Service Board would get together and discuss it and deliberate it, and from those interviews come up with a list of vetted candidates, approved candidates, right? And then that approved list would go over to the Maury County Sheriff's Department, and they would hire sheriff deputies from off of that list. Here they're saying even those first level job interviews, the debate that happens around them to decide whose name goes on the list and whose doesn't, even that is subject to the Open Meetings Act. Because the nature of their debate is going to have a profound influence on public safety eventually, right? These are the people who may end up getting hired as sheriff's deputies in that county. And you think, my gosh, job interviews are subject to the Open Meetings Act? We have at least one very strong opinion here that says that they probably are. And that ought to give us some idea then about how seriously the state legislature and the state courts take this idea of open meetings and keeping everything on the record. Let's talk about electronic communications a little bit. If one of you emails your chairman and said, hey, here's a news article I found that is related to our industry, our practice, I'd like to discuss it at the next meeting. That's fine. If one of you says, this news article brings up a topic of conversation I think we really need to address, something changing in the field perhaps, that we need to look at in terms of our licensure requirements, I'd like to include it on the next agenda. That's fine. But if you say, by the way, I read this news article that has some horrible thing to say about one of our licensees building that high-rise downtown, and we have to do X and so about that. No. Now we're crossing the line again. Now we're getting into that idea of you're offering your opinion as part of debate, as part of deliberation about what you might do in an action, and that needs to be on the record. This sort of relates back to that executive session question again. If one of you emails Mr. McDonough and says, I have a question about the legal consequences of something the board has done. Look, we took this action, and gosh, I'm just not sure how I feel about it. That's what he's there for. Please give me your legal opinion as to how this is likely to shake down. Excuse me. If you say, well, I went out and spoke to a high school or to a professional group and I didn't have the board's authorization to speak on their behalf, and now somebody's upset about it, that gets into the type of thing that is more likely to be a violation of the Sunshine Law and less likely to be something that your board counsel can help you with in terms of being covered under an executive session exception. This is where it gets really dicey. This is the crosstalk between you all as board members that you really ought to seek to avoid, if at all possible, for safety's sake. As I said earlier, if one of you picks up the phone or initiates an email to another, the courts are going to say that's not a chance meeting. That's not an informal assemblage. One of you took the initiative to contact the other. And so if one of you takes the initiative to contact the other after a bad ice storm, as of a couple of weeks ago, and says, listen, I know we go to church together. I know you're in a bad part of the country right now, and y'all got hit pretty hard over the weekend. Are you doing all right? Are your kids okay? Or, I saw your little girl in the school play the other week, and wasn't she just precious? The actual content of that, look, we all know that's fine. But that's not what the world is going to see first, is it? The first thing they're going to see is you've got members of the Contractors Licensing Board talking to each other off the record, off the books, where nobody can see. What are they saying? Later on, they'll find out that it was perfectly innocent, but in the meantime, it's a world of headache for y'all. It raises a red flag, what in the law they call the appearance of impropriety, and for safety's sake ought to be avoided. All right, electronic attendance. We'll move on to a little bit lighter material for a minute. You know that if one of you is not here in person, you can participate by telephone, and that's fine. At that point, all of your votes have to be roll call votes. You can't do all in favor, say aye, all opposed, say nay. Why? Because the state legislature wants the public to be able to know which of y'all voted how. And the way to do that is that if one of you is not here, to make everybody go down the line, and that's when you'll see Director Lazenby giving you, roll call votes and calling out your names so that everybody can be on the same page. There are, if a couple of you can't be here in person, but there are enough of you here in person to make a quorum, then fine, you go along like normal with your roll call votes. If the number of you that are here in person is not enough to make a quorum, and the only way you get to a quorum is by including people on the phone over the PA system, then the way to do that is with a statement of necessity. And Chairman Brudd's probably done this before. You're required to adopt a statement of necessity. It's nothing formal, it's simply a statement for the record that says, look, we have a public trust, we have a responsibility to go forward with this meeting. The public business is such that we can't postpone the meeting, and so we need to, I'm making this statement of necessity. We have a need that we can't avoid to go ahead and move forward, even though we understand that the conditions are not optimal because we don't have a whole lot of people here in person. Once you adopt that statement of necessity, you move forward as normal. The only thing you're doing is making a note for the record, for the public, anybody that comes looking after you, to say, okay, there was a reason why they proceeded with the meeting without having a quorum of people there. And the act is going to be construed most favorably to the public and is all-encompassing and applies to every meeting of a governing body, except where the statute on its face precludes its application, or excludes its application, excuse me. That exclusion is complex. I promise it doesn't apply to you. It has to do with the public fisc. If you have an agency that has the legal authority to commit the state to binding contracts, that's where that exclusion comes in. Since y'all don't do that, definitely applies to every meeting of every governing body. Oh, let me tell you, that case down there, Shelby County, this is an interesting story, and it's kind of an important one. Shelby County Board of Commissioners had a long-serving, very well-respected member. This goes back to the late 1980s. Gentleman died in office, and he apparently was very well respected, and the record shows that it was a very sad thing. The gentleman represented an almost exclusively minority section of the county, and so three of his fellow commissioners who had been friends with him got together. I think the record says that they got together over the phone, and they said, "Look, it's very important that this man's district be properly and adequately represented. We need to find somebody from that same section to represent, to fill his chair." And so they got together, these three other commissioners. They, with the best of intentions, developed a short list and then eventually narrowed it down to one guy. And one of the commissioners called this fella and said, "Would you serve if we appointed you?" And he said, "Yes, I would. I'd be honored." So they get to the meeting. The whole meeting of the whole Shelby County Commission is on the record. It's above board. It's clean as a whistle, right? And they say, and the chairman says, well, we have this vacancy. It's very sad. It's unfortunate. Our condolences go to his family. But now the law calls on me to make an appointment, or calls on the commission to make an appointment to fill out the remainder of his term. Let's go ahead and do that. The gentleman that had been pre-selected, his name was nominated. There was an all in favor, say aye. He was unanimously appointed. He took his chair. And by all reports and accounts, served admirably in that position for months, 6, 8, 10 months, depending on who's counting. And then somebody said, well, wait a minute. There was no deliberation. There was no debate on the record. There were no other candidates' names proposed. You come to the meeting, this gentleman has passed away in office. One name gets thrown up, it's a unanimous vote, and now he's in. Something doesn't smell right. And so that member of the public sued. And sure enough, it again goes all the way up to, you can see there, the Tennessee Court of Appeals, which again, if you're counting, is a good 1 lawsuit and 2 appeals. And they said that is a textbook violation of the Sunshine Law. And so we talked about before the idea that the penalty for violating the Sunshine Law is nullity, as though it never happened. It was as though that gentleman had never been appointed, had never taken his chair. And what that means is that every vote he participated in where he was the swing vote, gone. Every committee he sat on, every subcommittee that he chaired, all of those votes, all of that work, undone. And Shelby County is not a small place, folks. The business of that county was basically, they rewound the clock by 6 or 8 months. It was a disaster politically, but of course, in terms of good governance as well. That, you know, there was a mountain of work, whereas they had been efficient. And so this is sort of the kind of moral tale of what can happen when you end up violating the Sunshine Law with otherwise the best of intentions. All right, public has a right to attend and observe your meetings, but not the right to participate. There you go. I have thrown you a bone this morning. You are not required to let anybody speak. You may, but you may also place reasonable limits on it. We'd like to have public comment on this, but we only have a half an hour due to our tight schedule. I'm limiting, Chairman, you can say I'm limiting everybody to 60 seconds. That's perfectly reasonable. You do have to treat everybody the same. You can't give somebody 30 minutes to run at the mouth and then cut everybody else off at 10 seconds. But you don't have to let anybody speak. Why? Well, because you've been commissioned to do a job. And if that's going to be interrupted, then that's not what the state legislature has y'all here for. I told you before that once we nail down what meetings are and what notice is, we're about 95% of the way there. Let's talk about notice quickly. 3-prong test for adequate public notice. Again, notice is going to be something that is dealt with primarily by Director Lazenby and her staff on a day-to-day basis. It's not something that you're going to engage in terribly frequently. I just want to gloss over it quickly so y'all know kind of what's going on behind the curtain there. The content, the timing, and the location of the notice are what the law says is going to be important. Contents of the notice has to reasonably describe the purpose of the meeting. So if you say on the agenda, today at the Contractors Licensing Board, we're going to be playing with Lincoln Logs, and the public gets here and sees you conducting substantive business, that's not going to work. On the other hand, you need to understand that you are not chained to some of the boards and commissions like once the agenda's been published, that's it. It's like Charlton Heston up on the mountain with the 10 Commandments. It's carved in stone and we can't ever change it. Not true. That's why there's always that line item at the bottom that says new business. Nobody knows what that is before you get it. And that ought to give us some idea then that the contents of the notice are there to guide us, and we ought not to deviate from them too much, but we're not chained to them either. Notice has to be posted at a time that is sufficiently in advance of the meeting to give the public an idea of when to be there. If you publish the world's most accurate notice 20 minutes before the meeting, that's not going to cut the mustard. The rule of thumb for the courts, by the way, is about 7 to 10 days. If you publish your notice of the meeting 7 to 10 days beforehand, the court is typically going to give you a pass and say, you provided adequate public notice. By the way, for the record, your notices of your meeting, if you checked on your website right now, you'd see notice of the date of every meeting y'all are having this year posted. So we're covered there. Location. If you have the world's best notice published in plenty of time in advance, and you publish it in the boiler room, in the basement, then how does anybody have a chance to find out about it? 3 usual methods for publication: the internet, the newspaper, and bill posting, stapling up a flyer somewhere. We use the internet. Courts have held at this point that that is the broadest possible circulation of anything. Virtually everybody has virtually constant access to the thing. Even the poor and indigent, the courts have held, can go to the library and get access to the internet. Your agendas and notices of meetings, well, not the agendas as such, but the notices of your meetings are published on the Department of Commerce and Insurance's big website, on your individual board's website, and there's even a email notification program that a member of the public can sign up for. And if there's a particular issue that they're interested in or a particular meeting that they're interested in, it'll shoot them out an email according to this automated system and let them know when and where that's going to be. Pretty neat. Our usual practice, as I've said, is to publish both on the department's website and on your website. And then we also make sure and stick a flyer. This is not really formally part of the notice, but we make sure and, as you've noticed, staple up a flyer in the lobby of this building to let people know how to get to the room so that nobody can say, well, it's a big building, I got lost, and therefore I didn't have notice. All right. Winding up then, I talked before about the legal effect of breaking the Sunshine Law, of not doing all of these meetings, all of this board business in public on the record. I talked about the consequence being nullity, and I told you that sad story about Shelby County in the late 80s. There is we now have, hot off the press, there is another practical impact, and that is a substantial cost. This is a case that was published on February 14th of this year, last month. And this is a Public Records Act case that also had some Public Meetings Act challenges. Member of the public sues a public body, a governing body, and eventually she wins. After a couple of levels of appeal, she eventually wins. And then she goes and asks for attorney's fees and said, I have racked up $70,000 of attorney's fees trying to get this commission to do the right thing. And originally the court said, no, you don't get attorney's fees. The rule in the United States is everybody pays their own lawyers. You got what you came for, you won against the commission, pay your own lawyer, go on home. She appealed that decision. And the next court up said, okay, you have to give her attorney's fees. And the next court said, okay, we have to give her her attorney's fees, but $70,000 is unreasonable. We're only going to give her 50. And the next court after that, now we're back up to the Tennessee Court of Appeals again, said, nope, she incurred $70,000 of legal fees getting the commission to do the right thing. $70,000 of legal fees is what the commission is going to pay her. Because if the commission had done what it was supposed to in the first place, she wouldn't have had to rack up those legal fees. So now we have this precedent at the Tennessee Court of Appeals as of last month saying a violation could end up having you all, if you get sued, if you lose, paying the legal fees of whoever had to sue you in order to get that stuff. So the Sunshine Law thing is a big deal. $70,000, y'all work on big projects. But in terms of your budget as a board, that'd make quite a dent in your ability to do your job for the next 12 months. So I would submit to you that that is worth considering as well. In a nutshell, then, Public Meetings Act is designed to make sure that absolutely all board business is conducted in a way that is accessible to the public. If you have any doubts in your mind at all about whether or not some piece of business that you all are doing is subject to the Public Meetings Act, then the person to ask would be your board counsel, Mr. McDonough. The general rule of thumb is that if there's more people than just you standing alone in your home, staring into a mirror, discussing more board business, that's probably something that needs to be done on the record. It applies to you individually and collectively as a board. Regular meetings, special meetings, emergency meetings, all covered, including committee, subcommittee meetings, all covered. That only exception, again, is that executive session where you can get together off the record behind closed doors with your board attorney to seek his sound legal advice. Notice for every meeting, then, you have to give adequate notice in terms of the content of what you're going to be doing, the location where you're going to be doing it, and the time at which you'll be doing it. You know, there at the bottom, I say be paranoid. That language is probably a little bit excessive, and I should probably change it. If you're paranoid, you're going to be too scared to do your job, and that's not what I'm trying to instill in you today. Certainly, scrupulously above board about the whole thing. Maybe that's a better phrase. Ladies and gentlemen, that's all I have to cover this morning. I appreciate your patience with our glitches. If you have any questions of a sort of general or theoretical nature, I'd be happy to address them now. If you have any sort of case-by-case specific questions about real-life particular issues, I'd encourage you to address them to your board counsel. Any questions or comments at this point, folks?
Thank you, Damon. Yep.
Thank you.
We'll go back to the original agenda, which includes adopting the agenda. Are there any changes to the agenda?
I've had a request for a member of the audience. Mr. Guy Avani wants to address the board.
Do that under new business?
New business.
Okay. Anything else? I'll take a motion for approval of the agenda.
Don't move.
Second.
All in favor, say aye.
Aye.
Any opposed, say nay. Motion carries. I'd like to discuss the hardships approved by the executive director.
These have all been reviewed and approved by a board member, and they have been posted on the website.
Make a motion, we approve the hardships.
Second.
Any further discussion on the hardships? All in favor, say aye.
Aye.
Any opposed, say nay. Motion carries. Next on the agenda is approval of the January 28th, 2014 board meeting transcript.
Move to approve.
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed, say nay. Motion carries. Next item would be license approvals.
Let's talk about the interview applicants.
Okay, we'll start with interviewed applicants.
Mr. Chairman, I have one.
Okay?
Interview applicant and license number 30644. I mean, this is not a new applicant. It's going to be a new applicant. Okay. This gentleman, and he is here, Mr. Smith is here, so if you have any questions for him. He's been in business 28 years, and about 4 years ago, he changed the name on a permit, and I think it was to get paid through TVA, and he was paid. An inspector from the area, or from the permit office, spoke with him about this, and then that was all that was done, and he's up for renewal, and someone filed an anonymous consent order is to surrender the license, voluntarily surrender the license, and then we're going to approve the license. Is that correct, Ms. Brown?
Yes, that's correct. In this instance, what happened was the board met and voted and asked for him to surrender his license by consent order.
A civil penalty attached?
No, there was not. So he is willing to surrender his license, but asks that you reconsider his application currently, and that's why he was asked to come in for an interview.
I met with Mr. Smith. Talked at length about what happened and future, and so I'm making a motion that we approve his license, but he is here if anyone would like.
Which Smith is it? There's 3 on our list.
It's A&S Heating and Cooling.
Okay.
Form of a motion, Cindy?
Do we do that now, or you want to wait till the end? Because I do have, yes, I put that in form of a motion.
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries.
I have another one.
Okay?
This was an interview, a new applicant, 67598. This gentleman drove from Mississippi as a new license, to apply for a new license. However, he has a felony due to a drug and burglary, and he is still in his transitional housing till October of 14, and then after that he'll be on 17 years of probation. So I denied him. Person that's on parole, and he's not even on parole yet. He has to complete his program. So I denied. 67598.
You want to move to deny it? Is that what you're doing?
Yes, I moved to deny.
Second.
Okay, any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries.
That's it for me, Mr. Chairman.
Mr. Chairman,
I'm sorry, was that custom electrical?
Yes.
Okay, thank you.
just move right on down the line, that way we can kind of keep it in order, but I've got 2 to present before the board. The first one is a new license application. On the license application, it revealed what appeared to be contracting without a license. Interviewed the candidate, and it does appear as though there could be reasonable belief that a violation did occur. And subsequently, after some discussion with board attorneys, I've presented them with an offer for a consent order of $10,000 in go ahead and grant the issuance of the license immediately, since it's been more than 6 months since the violations have occurred.
Once it's paid. Once the 10,000, the consent order is paid.
Yes, once the 10,000 is paid. And I think they are ready to make that payment today. License number is 61501. I think this would just, my recommendation to the board is to approve this. They have accepted the offer, and I think this saves a lot of investigation time. Obviously, according to them, the licensure is important. They really didn't think they were in violation, and I had a pretty good amount of concern about whether the fact they were or not. The local codes department is issuing the permits to them, and they're doing it on a per unit basis. However, there are 4 to 6 units underneath one roof, and I think it violates the spirit of the law. If any of you have any questions, I'll be glad to answer them, but I do go ahead and make a recommendation to accept this offer to them. Make that in the form of a motion.
Okay. Any discussion or a second for that?
Second.
Is there any further discussion?
I'd like to make clear, you're issuing a consent order, they'll pay the $10,000, then we will issue a license.
That's correct.
Upon payment.
That's correct.
Okay.
Chris?
Have a chance to speak with you prior or even after the interview today. I was here on different business with Board Member Mason, and I was approached by the interviewee after the interview was conducted. Based on the facts as I understand them, and again, I've been involved now for about 2 hours, I have serious question as to whether or not a violation actually occurred. The process by which these permits were issued, as I understand it, was on a per unit basis within these condominiums. There was no complaint, as I understand it, filed against the contractor. The contractor came in and, as I understand it, had a very candid and open conversation with you about what had occurred.
Well, wait a minute, before we proceed this way, Mr. Chairman, if the agreement is not accepted, or if this counselor is going to recommend that it not be accepted, then we would proceed, I assume, to a formal hearing. And now's not the time to hear arguments as far as a formal hearing is concerned. I'll ask counsel if I'm correct about that. So, am I correct about that?
That's correct, yes, sir.
So, counselor, if you're here representing a client saying that you're not going to accept what he accepted with Mr. Whittington, then I think your comments are actually inappropriate beyond that. And I'll ask you, if that's your case, then I'm sure Mr. Whittington's recommendation at that point would almost have to be that we proceed to a formal hearing, which will involve an investigation and presentation before an administrative law judge, and penalties which may or may not range anywhere from 0 to higher, and include court costs. So I'll just ask you the simple question: are you representing this individual, and are you stating here that he's not going to accept the previous recommendation?
I am representing the individual, and we've not seen the terms of the agreement.
So then,
I withdraw my second.
then
I think we need to be very careful, Chris, in exposing the members of the board so as to not be able to make a reasonable judgment in the case if that's the way they proceed. I think we were pretty clear that if they didn't accept it, then we wouldn't be able to issue a license today. And then we would have to proceed with a investigation, and the investigation, as Bill is saying, would then probably lead to a formal hearing.
Well, as I was about to say, one of the concerns that I had when speaking with the client, and I have been retained to represent the client, is any type of an admission that would go into that consent order, which would stay with this contractor, just as your public records.
that's what a consent order is, counselor. So
Mr. Chairman, I think at this point, we need to cut off discussion of the case and proceed under our normal procedures with complaints.
Keith, it's your call.
I've made a recommendation, and I really feel like it's the best, because I believe that once the case is investigated, and I hesitate to say any more, counsel, but the board could arrive at a completely different conclusion, or it could arrive at an entirely harsher conclusion.
So Keith, what you're doing is making a recommendation for a settlement.
Yes.
Okay, well then that is appropriate. And, okay, I see what you're saying. So your motion is still to make that recommendation for a settlement?
That is still my motion.
We need to know whether or not the applicant wants to accept that.
And whether they accept it or not, then they'll come back to us on. Is that the way it'll work, Counselor?
We can go ahead and proceed with the vote.
And then if they reject it, then we move to our regular
We
order of
move to
business.
Plan B.
I just want to be sure we don't violate, our
Board members, let me just interject for a second here. This is for issuing a license. So what you're considering is the license application. Now,
yes, and his recommendation was that he be granted it if they agreed to a consent order. And that was his reasonable recommendation, or in the board member's view, it was.
correct, so
And if
in,
they reject that, then we come back with our regular order of business.
yes.
Okay, then I second that motion.
Whittington, may I interject? We haven't seen a consent order. It's like we're agreeing to something that we haven't seen. And that's very problematic for them. Again, if it includes language that they admit that they violated the law, that has repercussions that can follow them for the rest of the license. Typically, the consent order is right there at the interview, and I think that's what's different about this, and it may be that it's because Jenny Taylor's not here today, I don't know. Typically, when I'm here, we have a consent order, we can look at it, we can review it, and either say, yes, we agree to it, or no, we don't. And I guess I'm trying to reserve the right to at least review that on their behalf.
The only thing we're trying to do is, it was stated to me by your client that it was of the utmost importance that they get the issuance of a license.
Yes, sir.
We are trying to speed this process along as fast and rapidly as possible.
Yes, sir.
And the agreement was that they would have the payment, we would have the consent order. If they signed the consent order, they would receive the license. Now, I can't help the fact that the consent order is not signed, but we can wait 2 months when the board meets again, and the board can approve it then, if you would prefer to do it that way. Or we can give notice of 7 to 10 days, and the board can have a conference call and approve it in 7 to 10 days.
But would it
I'm
be?
just trying to think for the convenience of the board while we're in the meeting to get this acted upon. This is our standard method of approval of a license that's in question, is for the board to agree upon the approval of the license.
We've got a $10,000 check sitting right here. Again, my concern for the client is
the language.
The language, which I haven't seen any of it yet.
Okay.
And typically, we have a document that we're able to look at, and I can say to the client, here it is. It's basically take it or leave it, but I don't have anything to hand to them to say take it or leave it.
We're not going to be able to have that done before the end of the board meeting, will we?
Actually, I do have a draft of a consent order that I can share with Mr. Craven. He and I can step outside.
It's fine with me.
Can we go ahead and proceed?
We'll move on with the next case, and then when she returns, if you all have agreed to it, then we'll pick it back up.
Thank you.
Okay.
The next one I have is home improvement license number 7800. It is an application. It's a first-time applicant. The applicant is a resident of Davidson County. On the application, they mentioned or listed 3 contracts over the $3,000 limit, which put them in violation of our home improvement license. The applicant has agreed to a consent order of $1,500 for the 3 violations, and upon receipt of the payment of that, will receive his license. And I make that in the form of a motion too.
Second.
Any further discussion? All in favor, say aye.
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 Any opposed? That motion carries.
What's the name on that? We don't have numbers.
7,800.
What's
Oh.
the name?
That is United States Roofing Incorporated.
Okay, thank you.
That's all I have.
All right. Jerry, do you have any?
I have several.
Ronnie? Okay.
67649 Provision Construction Group. Have a young man here that has a felony. He was 16 years old at the time. He had confrontation in school with somebody. He was approached by a friend of his, said, look, we need to get even with this guy. What can we do about it? He turned around and had talked to another buddy of his, and they decided, well, why don't we get a gun and kill him? The boy, after he thought about it, said, this is not what I want to do. I don't know why y'all are putting me in this position. So he called and tried to rescind what was going on. Just so happened that the person that was going to do the shooting was an undercover policeman. Young man went to jail, juvenile court, detention center. He was there about 8 months. Then he went to boot camp. He was advised by his attorney to do a plea bargain, which he did. He's 28 years old now. This happened in 2004. He's clean, very good, real nice young man I interviewed. Don't have much problem with that, but he's trying to get a BC license. He's been working for a company as basically an estimator rather than doing any real work on the job, hands-on. So I held the license up more for his experience. Company that he's worked with, he has done work on the job, but when you fill out an application, he was writing down, he understood that he had to write down bid process is what he did. Well, he never did any bid because he was working for a company and they'd send him on a job, do this, do that, and whatever. So he's going to get a letter from his employer, everything that he's done. And at such times, he's going to send it to Kathy, and then hopefully send it to me and let me review the work that he's done. And I feel like if his experience is I like to issue him a license at that point. Be a small, I mean, it's a BC license, but it's very nominal as far as money-wise. I think it's about $125,000, I think. Subject to his experience.
Second.
Thank you.
Give us the name of that licensee again.
It's Provision Construction Group, INC.
Okay.
And I have another one.
Hold on.
I'm sorry.
Get that one approved. All in favor of Provision, say aye.
Aye.
Any opposed? Motion carries.
Have another one, Paragon Plumbing, LLC, felony. He was discharged from probation in 2009. This is kind of a unique case, so to speak. Had a felony. His felony was drug-related. Let his son drive his truck. His son had some cocaine in the car, left it in the car. Dad was driving the car, got stopped. So Dad got in trouble for it. Dad took the hit. He didn't say that it was his son's or anything like that. He went to jail. He's been discharged. He has been a plumber for about 28 years, and he's trying to get his license under the name of Paragon Plumbing LLC. And I'd like to make a motion that we approve his license.
Any discussion?
Did he complete probation in 2009?
Yes, ma'am.
Okay.
All those in favor of Paragon Plumbing?
Aye.
Aye.
Any opposed? Motion carries.
I have another one that is a felony that happened 30 years ago. Actually, he has a license. This gentleman right now has a license in Louisiana and, let's see, I believe 3 states, other states. Louisiana, Arkansas, and South Carolina. And he has applied for an unlimited license here in our state. He on financial statement. PCB license that he's applying for, and I'd like to recommend that we approve it.
Second.
Second.
It's, I'm sorry, it's Osage, O-S-A-G-E Contractors, LLC.
Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Thank you.
Bill?
I have 6, I believe. HI 7798 Meteorite Roofing was called in because there were several complaints, or 3 complaints, from companies for which he was qualifying agent in the past. He explained all of those. It turned out that it was mostly very minor in nature. He explained them to my satisfaction, and I move that we approve that application.
Second.
Any discussion? All in favor of Meteorite Roofing, say aye.
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 Any opposed? Motion carries.
On HI 777, which is a pretty old applicant, he Beneficial Builders, he was asking for a reinstatement as the license had expired in December, but it turns out that he has a job in which he contracted over the limit, in fact, nearly twice over the limit. Did not show up for the interview. He's actually based out of northern Mississippi. I, of course, don't want to reinstate at this time. I recommend that we open a complaint on the contracting over the limit and defer any consideration of the reinstatement until that's resolved.
Second.
Any further discussion? Okay. All in favor of the motion for Beneficial Builders, say aye.
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 Any opposed? Motion carries.
On HI 7747 Southern Roofing Company, there was a question about contracting over the limit, but not much over the limit. And after questioning him about it, there is some legitimate, and I think, questions in my mind about whether or not that was really a job or 2 different jobs performed time limits apart. So because there's legitimate questions about it, I recommend approval of that application.
Second.
Any other discussion? All in favor of the motion for Southern Roofing Company, say aye.
Aye.
Any opposed? Motion carries.
On license number 67617, Water Scope Pools, the applicant is a current employee of the state, the Department of Environment and Conservation, wants to go into business for himself. He asked for a BC 26, which is swimming pools, 29 landscaping, 30 fencing, and in the course of discussion, we included BC 28, which is excavation. He has sufficient experience for 28, 29, and 30, which is excavation, landscaping, and fencing. In my view, he does not have sufficient experience in the swimming pools area. His family has a swimming pools company in Kentucky. My recommendation for him was to go and get some hands-on, actual, work-at-it swimming pool experience, at least 3 installations and more if he can. And that my recommendation is that we approve him for a BC 28, 29, 30, and then he will, if he gets sufficient experience and can demonstrate that, he can come in and do an ad class application at a later point. So that's my recommendation for this for water scope pools.
Second.
Any other discussion? All in favor, say aye.
Aye.
Opposed, say no. Motion carries.
No license number assigned yet, Sun Pools of East Tennessee. I mentioned this at the last board meeting. This gentleman came in. He is he's in his 70s, I believe. He's been in business for many, many years here and in Florida. He, in my view, has been as much a victim as a violator in the past of bad and unqualified accountant, people who've also taken advantage of him. But at the same time, he's responsible for his own company. Last time, I made the recommendation that he voluntarily surrender his license, that he pay a $5,000 consent order, and that he be allowed to come back now and demonstrate that his business affairs are going to be handled in a proper way, and that he then have the opportunity to have a new license issued for a company to continue work. He wants to work for about 4 to 5 more years. He also had a felony from about 40 to 45 years ago, which he's not had any problems since then. So my recommendation is, and we also lowered his limit down to $300,000. I think it was $1 million before, and we're not going to have that high limit on him. So my recommendation is to approve this application for a new license. He has already paid his consent order for $5,000 and has submitted a new license, demonstrated to me that his business affairs are going to be supervised in the proper way, and he's going to take the right responsibility. So that's my recommendation for Sun Pools of East Tennessee.
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
And finally, 67534 Adventure Guild, which does zip lines. And I understand our first ever license for a zip line was granted in 2008. He's done one he did one in Chattanooga. He's done them all over the country. And he has been working with the related board to this department, which is the Elevator and Amusement Device Board, about zip lines. There was a project in the Chattanooga area that had a licensed general contractor that we would all recognize putting it together, and this was a portion of that, although he didn't really act as a subcontractor, but he had to kind of act under their direction on how to install it. But he didn't have a license for it, and he probably should have. That's 4 years ago now. He's on some national boards that actually oversee zip lines and recommend the proper things for him, and he is anxious to do right. My feeling about it was that he thought he was working through the proper board. I don't think there was any intention of a violation here, and yet there was. And so my recommendation was for the minimum civil penalty consent order, that he would pay a $250 consent order and be issued this license without any probationary penalty.
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
That's all of mine.
Do you have any, Ernest?
I have one for Jones Paving and Construction, number 67688. He was asking for a paving contractor's license in the amount of $350,000. He's had one felony, and that was 19 years ago. So I'm recommending a $250,000 license because he's done work and his financial supports that monetary value. He's done joint ventures with other contractors, and he wants his own license. So I'm recommending.
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. All right, I had 5 of them myself. First one was Stevens Homes LLC. They were brought in for an interview based on the experience they listed. He convinced me that he had a lot of home building experience. Most of it was 20 years ago, but I would recommend approval based on the experience that he presented. He's a realtor at this point, but he has been a builder before that.
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Second one was ARS. They were questioned about their mechanical experience. They're applying for both a GC license and a mechanical license. This woman has an employee with the mechanical experience, and I've asked her to submit his resume. And once we receive that resume, I would recommend that we issue the license. So I've noted that as a qualification for approval on the application form. So I'd move for approval once we receive the resume with the HVAC experience.
Second.
Further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Third was Brian Young. His application showed a negative net worth. After discussion with him, he agreed he wasn't ready for a license, and he is withdrawing his request at this time and will be back to us once he has a positive net worth, or not net worth, but working capital. So I would make a motion we just table his license at this point. Other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. The fourth interview was Thermal Tech. They're a roofing company out of Michigan. They do specialized roofing for high-temperature buildings. They performed a job recently in Chattanooga, discovered that they needed a contractor's license, and made application, revealed that they had bid and performed work in the state of Tennessee, and he is willing to accept a $1,000 consent order, and that would be my recommendation, to issue him a license with payment of the $1,000 consent order.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. The last one was CTR. They're a specialized company that does piping work for gas that's used in refrigeration systems. It's minus 200 degrees. We didn't really have a classification to put him in. He says that he does work all over the country. There's only one other state that requires him to have a license. Since the value of his work was over $25,000, we've asked him to get licensed under a specialty classification, and I have suggested that we waive any penalties due to the fact that the type of work he does doesn't really fall within a classification that we currently have. So, discussion. All in favor, say aye.
Aye.
Any opposed? That motion carries.
Mr. Chairman, I'll bring up one more. Actually, we'll revisit it, and I will restate my motion for license number 61501. It is a CMC-A license, that we grant the license upon payment of a civil penalty of $10,000 per the agreement that both parties have agreed on, our state's attorney and the applicant.
What was the violation?
They didn't have a license, so actually
Unlicensed activity?
unlicensed activity.
Okay. They've acknowledged that they've done unlicensed activity and going to pay the civil penalty?
Yes.
Okay.
Is there a second?
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. Just in case there were some that we didn't bring up, I'd like a motion to pass all the interviewed applicants that.
I move that we approve the interviewed applicants list with the recommendations as made by the board and by the individual members.
Second.
Any other discussion? All in favor, say aye.
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 Opposed? Motion carries. That's my agenda. Tell me what's next.
LLEs?
Okay.
Don't we need to do the waived applicants? I move that we approve the waived applicants list and incorporate any recommendations made by the individual board members.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? All right. That motion carries. LLEs.
I make the following in a motion: 27314, hold, need an exam score; 30820, approve; 43003, hold, need an exam score; 52613, approve; 56890, hold, providing employment information in the trade; 51113, approve.
Second.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? The motion carries.
Did we include, when we did the waive, did we include mode combinations, increases, and name changes?
No, that comes in the revisions. So we still have revisions in LLP.
Would you like to make that motion, Bill?
Well, I don't want to get out of your agenda.
That's next.
I was kind of following along on the pad, and they seem to be kind of out of order on that, so.
I agree. I apologize. We need a motion for approval of the revisions.
So moved.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Limited license plumbers would be next.
Make the following in a motion: 2262, hold, need an exam score. 7-4, hold, need an exam score. 579, not approved due to incomplete application.
Second.
Okay. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Mr. Chairman, at this time, I'd request a short recess. There are about 8 cases that were not originally placed on the legal report, and I would like to meet with the residential subcommittee prior to presenting it to the entire board.
Are they not on the printed legal report that you presented?
They are not. I was under the impression that they were.
Mr. Chairman, let's proceed with the legal report that has been done, proceed with some of these other things, and then try to do this a little later in the program. Can we do that?
Whatever is the pleasure of the board. We can do that, or we can take a short recess.
I'll through all the rest of it? All right, that's fine. I don't care.
Take a recess?
Sure.
All right, we'll take a recess.
That read the bill. Because we have members in the audience.
Benton, is that about a 10-minute recess or what?
Probably. There's just about eight cases that are on there, so they'll just need to.
Yes, we do.
We'll get there. An hour later.
Okay, thank you. No worries.
You'll get better. Got the ones that are missing?
Yeah, that's.
This is them
all
right
those. Yeah.
These right here?
Yeah, those and.
Oh.
Yeah, sorry, it came off the.